goes. All right, we are recording. All right. I honestly don't remember exactly where we left off on things, but I know that our notes, like the stuff that we were going through, was mostly around client contact. So at this point, I think we're just kind of continuing to move through the various like categories, excuse me, of performance standards. Do we think there's anything more we need to say? And let me put up the one that we did, the working draft that we've got so far. Is there anything more we need to say, do we think, about client contact?
Can I take a look at that draft? Did you send it out?
I don't think so. It's been in the, or I'm not 100% sure. It's been in the Dropbox.
Okay.
And it's mostly just the client contact within 24 hours.
Yeah. Oh, there we go.
Yeah. No, I know our manager put together this during a period a couple of weeks ago when we thought we needed to get something faster for inclusion in the contract. I don't know. Yeah. I don't know that I think it's more just we're going to use that as a reference potentially. And I don't know that it's much more than just a restatement of what's in the OSB civil commitment standards. So, okay. All right, but okay, so if we've got role and client contact, let's move towards education, training, and experience. And keeping in mind that a lot of that is covered by the qualification standards. So it's not necessarily something that we need to be overly explicit around. Yeah, go ahead.
Can I propose one thing regarding in-person contact within 24 hours?
Okay.
I would want a clarification on, because it does say depends on where a client is domiciled. I think that it also makes the most sense to say if that person is hospitalized, contact within 24 hours. We do have clients who are out of custody,
Okay.
or if they're in a group home, I usually don't prioritize seeing them within 24 hours, especially in IDD cases, because that's a 30-day investigation period, and almost all of my clients have been through that process before.
Gotcha. Okay. So this may be a place where we drafted this based off of the mental health commitments, not necessarily IDD. So, okay, cool. Let's specify that out further. So, and I know that there are some theoretically mental health commitments where the 5-day clock doesn't start at the filing of the notice because the person has not been detained.
Right.
So how about if detained, in-person contact within 24 hours, would you consider the group home setting to be, like, does that resolve the issue with respect to group homes and things like that? Or do we need to make an exception or something like that?
With group homes, frequently that person is already under a commitment, not always. So when it's a group home situation, I usually will, I still try and schedule within, well, I guess it depends, because again, with the IDDs, because the investigation period is 30 days, I don't often prioritize seeing them until it gets closer in time to when the investigation would be over. So, but they're frequently already committed and so detained under the previous commitment or the current commitment if it's a recommitment situation. Same with people who are committed to Oregon State Hospital and
Mhm.
the state is seeking recommitment. Those are not ones that I prioritize seeing within 24 hours because one, that's just not possible for me a lot of the time. But two, there's not really much function for me in that until I get the medical records and I've had a chance to at least review some of it so I know what we're going to be talking about. Otherwise, I'm spending the time going to the state hospital to spend 5 minutes with somebody who I'm like, I don't know what we're going to be talking about yet, so I'm going to come back and see you. I usually wait till I have the medical records so I can say this is what we're going to be talking about at the hearing.
Okay. Um, when somebody is initially committed, so then, because this is an area that I never handled any IDD commitments. So this is just an area where I don't have the base knowledge. For an initial IDD commitment, is the timeline the same for a mental health commitment?
Yes. Oh,
Okay.
sorry. No.
No. Okay.
Initial IDD and recommit IDD are treated the same, which is there's a 30-day investigation period from the date of filing the petition.
Oh, okay. Okay.
And
So,
usually they used to file recommitments in, and again, this is Marion County, and Marion County has almost all of the IDD petitions that get filed because that's where a majority of the group homes that like the stabilization and crisis unit group homes are located. They will file a new petition within about, I would say, a month and a half of the like end of the previous commitment period so that they can capture keeping
mhm.
that person in, but we're also getting as close as they can get to the end of that previous commitment. There can be a warrant of detention issued if there is a gap in time in which the previous commitment ended and the current investigation is happening.
Okay.
Um, but that it's also a pretty strict 30-day window. There's no statutory allowance for a continuance or an extension of that investigation period, unlike in the mental health commitment investigations where there is allowance for an extension of the 15 days.
I know in the mental health commitment schema, they're called PAMIs. What's the term for them in IDD commitments?
There is not an identified term.
Okay.
I use the same, I try to mirror PAMI language for IDD, so person alleged to have an IDD. So P A
PAIDD, maybe?
P A I D D would
Okay.
be appropriate, I think. I think that would communicate what needs to be
And
communicated.
is there a similar mechanism in an IDD commitment that would start a short clock? Because like PAMIs, if they're not detained and the citation hasn't been filed, no clock is running. It doesn't start running until one or the other of those two occurs.
Hmm.
Is there a similar mechanism in an IDD commitment?
No.
Okay, so the timeline for IDD is just always essentially 30 days.
Yes.
Okay, okay, cool. Thank you. All right. Does this language sound, oh, we need to actually put a standard here. Uh, In-person contact
Hmm.
within, say, 7 days?
I think 7 days is great. I unfortunately am not always meeting that
Sure.
currently, but it's good to have that listed out as
As
a
as
goal.
a performance standard, yeah. Okay.
Yeah. Um, so for the previous paragraph, I would say for MH initial commitments if the PAMI is detained, not or if the PAMI is detained. Because I would say for recommitment, if the PAMI is detained, 7 days would also be appropriate. And which is what's captured in the second paragraph. But for
So
people,
do we need to even have the PAMI detained portion in that first paragraph? Or would it just
yes,
make sense for all all mental health initial commitments, in-person contact within 24 hours? Would
you
there
can
be a
still
situation? Go ahead.
you can still have a mental health initial commitment where the person is not detained. So there is a petition that's filed that starts a 15-day period of investigation
Right.
with that person in the community if that's a two-party petition that's been filed.
What would you say the timeline should be on a non-detained?
I would say if there is that's part of the problem is I have had clients who, for example, were in the community living alone, and it was alleged that they are unsafe, like they are
Hmm.
unsafe around other people. And so, for my purposes, if I have no phone number, that is not a safe thing for me to do, to go have contact with my client in person.
Oh, okay.
So I frequently don't end up having contact with them until we know there's going to be a hearing in this circumstance. Because of that, I think if we wanted to have a universal standard for every situation in this, attempt to make contact within 7 days, or however it's treated in a criminal case, I think
Mhm.
would be appropriate. If there's a standard for contacting an out of custody client in a criminal case, that
Jordan,
would be
Make
appropriate.
the attempt within 3 days.
what is
Three
that
days is
language?
the
Yeah. I have it pulled up.
Allison's
I can
going.
just read it to you. For out of custody clients, initial outreach to schedule an initial interview should occur no more than 3 business days after assignment to the attorney.
I think that's appropriate to mirror in this particular circumstance, two-party petition where the person is not in custody. And this is very particular to appointments made when the petition is filed. Most jurisdictions in Oregon, the appointment is made when the hearing is scheduled. And so perhaps it should be attempt to contact within 24 hours of appointment in those jurisdictions, because that's going to be a tight timeline.
Okay. Okay, does that all look like it captures what we're saying? And welcome, Allison.
Right.
I think that, yes, I think that would be appropriate, what you've written.
Allison, how do you, I know you just kind of jumped into it, but
We're just talking about the contact requirements after appointment. Yeah, I think in-person contact within 24 hours is definitely appropriate. We talked about this a bit the last time, I think, like where I think we need to be thoughtful about or talk with providers and courts about because like we will have Lane County cases. We've got one right now where the patient is at Cedar Hills, which is in
Yeah.
Portland. And so like ideally we wouldn't be taking that case. Like ideally it would be somebody in Washington County that is taking that case, because it's a lot for us to go up to Portland to see our client. But I do think that in-person contact needs to be prioritized.
Mhm.
And
Okay.
I think, I mean, I know that for some of the eastern counties, there's not holding hospitals in many of the, like in Morrow County or whatever, there's not a holding hospital there. So that person is going to be sent somewhere else. And I mean, I think we need to prioritize like in-person contact within 24 hours. I'm just imagining that there's potentially some situations where like the closest attorney might be like 4 hours away from where the patient actually is. And so how do we factor that in?
And I think we had a note about extenuating circumstances not to excuse from this.
Yeah, I think if we just like if we, and I don't know how we do this, but if we just communicate, so like if it's a Morrow County case, but the person's being held at St. Charles and Bend, then perhaps we talk to Deschutes County attorneys about taking that case and then I mean, it becomes complicated because if the patient is being transported to that county for the hearing, which sometimes they are, then the expectation would be that the attorney is going to be in person at the hearing as well. So it just becomes a little complicated.
Okay. We can move this.
And I don't know if maybe there's like a co-counseling model that can be employed in those situations. So like an attorney in Deschutes County goes and visits the patient in person at the hospital, and is communicating with the attorney, and maybe there's like a video visit with the attorney that is then going to be with them at the hearing or something like that.
Same with commitments
We did
initiating
have,
at Oregon State Hospital. Most of the time, I think they file it in Marion County. And so I'm then, just running over to the state hospital as soon as I'm able. But they may file it where that person is domiciled. And so it may be filed in their county of origin. And then they'd have to either come to Marion County, or there could be another co-counsel circumstance that's set up.
Okay.
I will say we did have a discussion in the criminal work group standards about whether or not there was a qualitative difference between in-person meetings and virtual meetings. And the work group leaned toward virtual meetings being just as good as in-person meetings. I don't know if it's the same in this context, but
No, I mean,
No.
it might be depending on who the patient is, but for a lot of them, no.
I would say anyone who has a psychotic disorder or an intellectual or developmental disability, it is qualitatively different.
Yeah.
And that's a large majority of the people in this population.
Okay.
Like I think if you were doing a diversion for somebody that was just like a danger to self, like somebody that just had like a suicide attempt, and that's their diagnosis is not related to anything psychotic, like maybe depending on where they were at, you could potentially get away with a video visit, but there's not very many, and you just don't know really.
Yeah, even from the documentation we receive, we don't necessarily even know what their diagnosis is.
Yeah. Also, the hospitals are like unreliable in like helping us to set that up. So it's just like a bunch with the short timelines, it's just like hurdles like that would really outweigh the possible benefits.
There are hospitals I know I have to just show up as soon as I can and demand to see my client.
Yeah.
Okay. Right. Do we have anything else we want to mention regarding? I don't like. So based on my memory and experience with this, how much of a provision do we really need for ongoing contact? Well, let me rephrase that, right? So what are the circumstances under which we might want to impose or have a standard regarding ongoing contact with a client?
I mean, a commitment only lasts 10 days at maximum. I mean, I guess now with the double diversion, like there's a potential that you could have a client on a diversion for 28 days. But like, I mean, if you're preparing for a commitment hearing, like, I mean, I think I have contact with my client every day. I mean, like that's not a lot because it's only 3 days that I'm appointed to represent them, 3 or 7 days. But I mean, you need to have as much contact as you need to have to prepare yourself and them for the hearing.
For diversion cases, there is a statutory requirement of 24 hours within receipt, which can get complicated. My jurisdiction will often forget to file it or submit it to counsel. So that would
Forget to file
necessitate
which?
the diversion paperwork.
Oh, gotcha.
I've had a couple of illegal diversions as a result of not receiving the diversion paperwork.
Gotcha.
So contact for anyone on a 5 business day hold. There really should be contact on the 3rd business day to confirm whether there has been a diversion filed.
How do you think that
Um,
plays in with the new diversion time? Because now the diversions can be offered at any time, and I guess they like it's just now instead of diversion being the recommendation from the PCI, it's now a whole separate document, like an offer of diversion or notice of offer of diversion.
It's, I mean, it's still the same kind of concept. Like I think the investigators are still the ones that are, I mean, like we can sort of negotiate for diversion explicitly
Yeah.
a little bit easier under the new version, but it's still the investigators by day 3 are still making the call of diversion or not. It's just that now they can also, they could revise that on day 4 or 5, and like now we change our
Yeah, I was
mind.
gonna say, my understanding was now that it can be basically any time until the court makes a decision on the, I mean, theoretically, you could, in the middle of a hearing, say, we all agree to a diversion and we're good, or something like that.
They could, but I think day 3 is still it's going to be an important kind of crossroads for the
Okay.
investigators to be determining, like, are we moving forward with the hearing or what are we doing? I mean, I guess they all along they have had the ability to decide if they wanted to offer a diversion earlier than day 3. I just know that they typically want to have as much information as possible before they make that decision, so they usually don't until the 3rd day.
Okay.
But they're definitely, I mean, that's at least here they don't make a decision about hearing or not until day 3, and I would imagine that that's going to continue after.
We've recently had day 1 and day 2 diversions, so that is also complicated, but at the very minimum, I think contact on day 3 to confirm, and we had contact with your client, but then also confirming with the hospital their understanding of the basis for your client remaining at the hospital is important to capture circumstances where paperwork didn't get filed appropriately, and also capturing circumstances where the investigator is maintaining that because in our jurisdiction, the investigator will talk to the PAMI first to confirm, because if the PAMI doesn't want to do diversion, they're not going to extend it.
Right.
So, but we also talk to our PAMIs because frequently they will say, oh no, I didn't agree to that. I don't want to do that.
Yeah.
So
Contact with the,
yeah.
oh, sorry, Bailey. Contact with
No, go ahead also.
the hospital and the investigator.
Okay.
Do you think, Bailey?
I agree. Yeah, because just to make sure that there isn't something
Hold
that
on.
people have agreed to that hasn't been communicated.
Yeah. So I think we might
hospital.
be pulling out a different standard here, which is there's potentially an ongoing contact provision on its own to deal with your client, but now we're also talking about a separate standard. Here are people you should contact and approximately when. So hold on.
And I think why we're doing that is it's all so closely intertwined. It's not like in criminal circumstances where I'm calling my client or going to the jail and then seeing the DA separately. Everyone who's making decisions is often concentrated all in one building. So that's why that's often kind of intertwined.
Gotcha. Okay. Now, one thing I want to, putting this in the frame of other standards that we're working on and towards the structure that we're using for these, a lot of what we're trying to like split between are things that are musts, things that are shoulds, and things that are best practices. So this contact with the hospital, where does that fall? Is that a must, a should, or a best practice?
What's the difference between a should and a best practice? I mean, shouldn't we be doing best practices?
I mean, yeah, best practices, I think, are maybe even further on the aspirational side. Like the way I think we're conceptualizing it largely is musts are things where if they're not followed, we may have a contract problem where we might consider somebody not to be abiding by the terms of the contract. A should is kind of that this is still serious and maybe we should take this into account. Whereas a best practice is more, this is a really good idea. We want you to be doing this. This is where we're aiming for good practice to be. But failing to do this is probably not going to be considered a violation of contract obligations, if that makes sense.
And you're talking specifically about the contact with the hospital to confirm the nature of
Yeah,
their
look-
continued hold. I
Yeah.
would say in theory a should, but it will in practice end up being a best practice situation.
I agree with that. Although I do feel like some kind of contact, like I think the lawyer needs to be not necessarily responsible, but like some communication between the parties about like
Yeah.
what are we doing needs
Yeah.
to happen at day 3. And I think the lawyer should take initiative for that. Like it doesn't necessarily need to be like you talk with the
Yeah.
hospital, but just
That
like
should not have happened.
like what the lawyer should take initiative to say like where are we all on the same page about where this is going, because you need to know if you haven't already been told like are you having a hearing on day 5 or not. And
Yeah.
like I don't think the lawyers should be like waiting around to see if like they're going to do a citation or not. Like take initiative and be prepared.
Mhm.
Okay, so to put this in like a similar context under the where would I put this? Like here, out of court advocacy and dependency cases must advocate for client, like that's normal. But what I would say here is like should engage in case planning and advocate for a permanency plan and social services, help the child. Like this is a thing that's very much a should. You should be in contact with people. You should be engaging in this. If you don't do it on occasion because the facts of your case don't really fit this, okay, right? We want you to be doing this. It's a really good idea. Like it's kind of a, we really like, almost like we would accept explanations for this, for failing to do this. Whereas a must would be like, okay, if you're not advocating for your kid client in and out of court, why are you an attorney? Right?
Yeah.
But so does that help kind of frame what I'm meaning?
Yeah, I think there's undoubtedly like very well-oiled jurisdictions where there's like very good communication between the parties at all stages, and so like it's not unreasonable for the lawyer to just like wait until 5 p.m. on day 3 and they'll know at that point like are we having a hearing or not. And so like sure, don't, fine, I don't know if there's anything wrong with that, but I don't think that's most places. So I think what we want to emphasize is just that like the lawyer needs to take an active role in like being prepared for the hearing. And in most places that probably means don't wait until they tell you that you're having one to figure out if you need to prepare or not.
This is also an area where the differences in how counties appoint counsel is quite bare, because the contact on day 3 is only possible if you've been appointed at the time the case was filed.
Right.
Otherwise, if you're being appointed either when the diversion is certified or when the hearing is scheduled, then it's a very different situation.
We are appointed on day 3. Well, next month we're going to start a experiment of getting appointed at the notice of mental illness.
That's excellent.
But the current practices were appointed on day 3, and the expectation is you got to go to the hospital like on that day to meet with your client.
Yeah.
Right. And so, okay. So presumably in jurisdictions where appointment doesn't occur until day 3, I would assume that the appointment is only occurring because the PCI got filed, which indicates that,
Yes.
diversion's been offered or whatever, right?
Or
So-
they're the hearing, yeah.
So at that point, it's not necessarily like you kind of know at the time that you're appointed, here's the direction where at least most people think we're going, though they could be. I remember the last of these that I ever handled was, hey, we offered diversion, and I go and I visit, and my client's like, I don't want to do diversion. That's not a thing I want to do. Not like I didn't agree to this, just a blanket, I don't want to do diversion. I want to fight this out and have my hearing.
Mhm.
Okay. Okay, this gets complicated given the short timelines.
I mean, I think though, like, even though it becomes like sort of more impractical and certainly more inconvenient, like when you have jurisdictions that are appointing that late, if like there's everything, it's all musts. Like,
Yeah.
If you're going to have a contract for civil commitments, if you're in a jurisdiction where you get appointed on day 3, you must see your client on day 3. Like, you must have contact with them on day 3 and day 4. Like, you must,
Right.
like, there's no.
Oh, yeah. Okay.
Bailey, do you have our practice is that we don't request the full postponement without consent of our clients, and they need to have some like meaningful capacity to consent. If it's like we absolutely cannot be prepared reasonably, like in this amount of time, we'll request like a shorter postponement, like just long enough for us to be like constitutionally adequately prepared. But I know that some people have different perspectives on that. Do you have any, is there a practice in your office about that?
I would say it's about the same. Either my client is consenting to a continuance, or I absolutely cannot be prepared. Those are the circumstances in which I would ask for, and usually the shortest continuance possible. Like, I think the last time I had to ask for continuance and my client wasn't fit to like make that decision, it was a 2-day continuance that I asked for.
Yeah. I
Okay.
feel like it would be good to have some guidelines surrounding that, because I think there are some practitioners that sort of automatically request it.
Routinely say, oh, give me 7
Mhm.
days.
Yeah.
Okay. So,
And there's like, don't get me wrong, like there are very good reasons to request a postponement. Like, we do that. We've been doing that as like a softer version here forever, and people's cases get dismissed most of the time when we do that. But like, again, we only do that like when we've spoken with our client and we feel pretty confident that they have like basic capacity to understand what we're telling them and the risks and benefits, and they're like affirmatively telling us that they're okay with that.
Okay, so how about this with respect to that? Must consult with the client
Yes, before
Yeah,
the postpone. Yeah.
if possible.
I feel like the consult, we can work with the language of the consult, like what you've got to go in and you've got to at least see them and try to have a conversation with them. If they
Yeah.
lack capacity to consent, then request only what is necessary.
Yeah.
Mhm.
And I may be able to pull some of the language that we use in the, oh, I can actually show it to you. Hold on. Is it this one? Hold on, because this is our current language for the role of child's attorney, which brings up some of the same capacity issues with regards to, and we're going to need to restructure this a little. You can see some of my notes from our work group a couple of days ago. But the basic idea is the first like core function is assessing your own client's capacity, and then how you operate goes off of that.
Yeah.
So, and we can import some of that into this as like your role is defined by what's your client's capacity. If they have capacity to direct you, you follow what they do, you get their consent, all that sort of stuff. If they don't have capacity, then you're restricted and you have like, you're not a best interest advocate. You're a what would they tell me if they could advocate.
Yeah, I mean, I think it's complicated in the
Yeah.
like there's some important distinctions between a child client and a client with like serious diminished mental capacity. I think like definitely like to do a assessment of where you think your client's ability to direct you is important. But I think like for us, we never stipulate if our client doesn't have capacity to stipulate. Like there's never a situation where we like assume our client would want to be like in the hospital or civilly committed unless I mean, I guess there could be like a very extenuating circumstance where that would be the case, but that's certainly not our default. So I think to me, it makes more sense to me, like, whereas instead of the standard being like, what do you imagine they would want if they had capacity? I think you just default to protecting their rights. Like,
Yeah.
and in a civil commitment context, like it's not like that usually is like we're having the hearing, we're making objections, we're like doing we're being like basically protective. We're not like signing them up to go stay with their mom or whatever. Like if we've not talked to them about that,
For the cases I've had that have gotten to the point of having a commitment hearing, the amount of clients that I have had that I felt had the capacity to consent to commitment, if that was what they wanted, has been a very small number. Even
Same.
clients who I've had who want to be hospitalized, very frequently, I don't think that they can fully weigh the consequences sufficiently to do so. So, yeah.
Oh,
And
and
it has-
this is where
yeah.
you're talking about like stipulating to commitment. Okay.
Yeah.
Yeah, and that's the same for me. I think I can count on one hand the number of clients that I have done a stipulation for in my whole practice.
I think I've done one or two ever. I've done stipulation to recommitment. That's I think a little bit of a lower standard because that person has already experienced the deprivation and now has lived, that commitment period. And if they're like, you know what, I want to stay at the hospital, I'll say that's probably good enough, honestly.
Yeah.
But that's the only circumstance when I think that that's all that I need to reverse an objection to recommitment.
Yeah, I agree with that.
Okay.
Lots of times, I mean, I've never been present when the hospital or the provider, whoever is approaching the patient about recommitment. So I would imagine that there is a wide spectrum of information that's given to patients. And so some of the objections are more just like there was a lack of any time spent with them, like explaining what was happening or what their options were.
It can be that, and it can also be the length of time during which a recommitment is prosecuted, that they just get a couple more weeks of the proper, amount of medication that they'll then say, you know what, actually, I'm good. I want to stay here, or we're working on finding me a group home now when we signed the recommit, and I really want that group home, and I know if I don't stay here, then I might not get that group home, that kind of thing.
Do you have a lot of recommitments, Bailey?
We get quite a few at the state hospital.
Okay.
I would say it averages 1 to 3 per month at the most. I would say usually 1 to 2 per month.
Okay. And you only get appointed if they protest?
Yeah.
Okay.
Trying to think.
Yeah,
I'm trying to
otherwise
remember
if
that
they
bill.
the way the statute operates for Kevin and Jordan, the way the statute operates is if recommitment is sought, there's a petition
Yeah.
or a certificate that's submitted, and the individual can choose to not protest, and then they don't get counsel, which is kind of the negative part of that statute, is they don't have counsel to sit with them and fully explain the legal aspect of not protesting, because then they
Okay.
lose the ability to protest again.
Yeah.
Until there is another recommit, which is 6 months from that date.
An automatic appointment of counsel for recommitment, protest or not, was one of only 3 like consensus recommendations that came out of this stupid commitment to change work group. And then they put that recommendation in a bill separate from the 2005
Yeah.
build that died
Oh
in
my-
Ways.
Yep. Yeah,
That's
it was,
really
it
dumb.
was. What were the, yeah, never mind. Okay. Offline, I will ask you, what were the other consensus recommendations?
It was like solve healthcare. Like do better by the poor, basically, were the other
Okay.
two consensus recommendations. So that one was the only like actionable.
Substantive, actionable, yeah.
And it died. That's wild.
Well, yeah, and I know there were, whatever, yeah, okay. All right. We can definitely go further into the what do you do? I think we probably will need to go further into what do you do when you have a okay. Have
think
you
a
ever
lot-
run into a situation where a diversion was offered or recommended and you did not believe your client had capacity to agree to it?
Yes.
And what
Case
is
by
the
case
standard?
basis.
What is the standard for that?
That's tough because part of the problem is if I feel like my client cannot consent to a diversion, I am possibly then putting them in a position where they get committed when they might not have been. And that is really uncomfortable.
Mhm.
I do it on a case by case basis. I think I've only had one time where my client was certified for diversion. I met with them. They had made a significant regression. They were unable to consent to the point where I felt I had no choice but to request a hearing. But almost all of the time, I've had this circumstance where my client says, I object. I've waited a couple of days, went back and saw them again, and they said, "Oh, I changed my mind. I actually want to stay on the diversion." And that's my typical progress. But there was one where somebody made significant backslide to the point where I was like, "This person cannot consent, and I think it's unethical for me to like ratify this
Okay.
choice."
Yeah, exactly same.
Okay, so what I'm trying to boil that all down into.
I guess if I can just sort of say, like,
Yeah.
with diversions, like the investigator has already gone over and like talked to them about it. So like it's uncommon that I would go over to talk to somebody about a diversion and like it's not trending in a yes or no direction.
Mhm.
So like it's pretty easy, and like we do the same thing as well. Like if we just got nowhere with them the first pass, we give them a little time and go back
Yeah.
around, and like, usually we've moved on from like whatever the hard point was at that. So like it's not, I think the capacity to consent to a diversion sort of boils down to like, are they telling you yes or no? And like you sort of ignore the noise around that would like otherwise make you feel weird about this person's ability to enter into any kind of contract.
Yeah, I would tend to agree with that. If the person is completely incapable at a later point of saying yes or no, that's when I would need to say my client objects to diversion.
Yeah. Or I think, because I think like I also can only think of one time where I was just like, there's I just don't think I can like put my bar number on like this is a consent just given like the condition of this person here.
Mhm.
And so it's not even so much me saying like they reject it. It's just saying that like, I mean, they shouldn't be a candidate for diversion anyway because
Yeah.
like it's meant to be voluntary. But
Well, and therein lies, I think, where we're okay. So
I have to take my dog to get stitches out now, but thank
No
you
worries.
everybody for this
Yeah.
conversation.
Thank you, Allison.
Take care of the pup.
Okay, so I'm trying to sum that up. So generally speaking, like, yeah, Would it be, okay, hold on. Well, let me see, because we've got some, maybe this is the right language. Let's see this. Maybe something similar to, all right, maybe B here. If the client is able to verbalize a preference but not capable of making an adequately considered decision, the client's verbal expressions are an important factor to consider in determining what course of action to take. Client's lawyer may wish to seek guidance. Well, that part wouldn't necessarily work well in this context.
No, I mean, it can, I would say. It would be specifically the psychiatrist. Um, I One thing I might do in the circumstance that Allison and I, the very, very particularized circumstance that Allison and I have discussed, or also when someone consented and then withdrew their consent, is I would meet with the psychiatrist and see, are
Mhm.
they making strides? Are they like falling back? Are they taking their medication? Like, where are you at in terms of this diversion? If, for example, the doctor is saying, you know what, I think they're actually not going to make it through diversion, and you know, they're doing a backslide and they're not looking like they're going to very quickly come back, that might be something that I use to consider, okay, this person can't consent and isn't going to consent in a couple days. I will need to pull the plug or you know indicate that
Okay.
this person cannot consent to a diversion. But other than that, I would say, um, and again, it's so touchy because there
Yeah.
are some people who, and
Well, they
again,
might,
yeah,
their capacity might be fluctuating
the
and
capacity
sometimes
can
very
fluctuate
rapidly.
very rapidly at times, and also the capacity to consent to a diversion being, I think, much lower than the capacity to consent to a
Commitment.
commitment or other things. I would say that the capacity to consent to diversion might be lower than the capacity to consent to a continuance in some ways.
Oh,
Just depending on the circumstances.
okay.
Um, might be about the same, but it's such a case by case thing that it's really hard to it's I hate to do it when you know, but it's kind of that because if my client is incapable of if my client is incapable of verbalizing a preference between say diversion or not, um
I mean, so we use like
yeah,
this in the dependency framework, we use this kind of catch-all. It's not necessarily about the individual thing. It's
right.
because there's all sorts of tasks or questions or stipulations or agreements or whatever that a child client could or could not have capacity for.
Hmm.
And it's very clear from the outset, your client may have capacity to make some decisions, but not others.
Right.
And if they have capacity, you follow their direction on those questions. If they don't have capacity, then you investigate and try and figure out what would they do if they had capacity.
Hmm.
Um, and it may very well be that it like, does that feel like a fairly strong, like, does that correlate here? Or
No.
is it that really we are defaulting instead of what would they do if they had capacity? The default, like where we head is what is the most protective of their constitutional rights?
I would say defaulting to what is most protective of their constitutional rights, in part because when talking about if they were fit, what would they want? With a child client, that can be easier to assess because you can spend more time with a child client, you can be with them in their element. You it's a lot easier to assess that than it is with a client who you've met for the first time. You only have 2 days maximum, maybe, to figure out what the decision is going to be. And it's so much more complicated of a circumstance than just, do I want to live with mom or not? And so I don't think that there really is room for a what would they do if they were competent analysis, because it's not something that we can really assess the same way you can assess a child's desires. Further, the protecting your client's legal interests can also be a seesaw type of thing. The reason for that is sometimes that is prioritizing having that person hospitalized for as short of a period of time as possible. Sometimes that is prioritizing the determination that this person is highly likely to have more freedom if they remain on a diversion than if they were committed. And that's a really hard line to walk. And again, a lot of the time that's just ameliorated by waiting a couple of days, as Allison and I have both recommended, because waiting that couple of days instead of immediately jumping on having a hearing can mean the whole difference for that person making a decision that is more informed or more fit of a decision, I guess, for lack of a better term.
Okay.
But if it's clear that that person is not going to recapitulate in a couple of days, then we have to make the decision, what will best protect this person's interests?
Okay. Okay. All right. I'm gonna try and get this all into what we've got so far into a more coherent draft by the next meeting, and try and get all of that in. So, okay.
Yeah.
All right. I think that probably puts us at a good stopping point for today's meeting.
It feels like we didn't do a lot, but we also did a lot at the same time.
We did a lot. I mean, we did a lot on a very narrow scope of subjects. And
Yeah.
some of the other stuff may be a lot faster and easier to go through because we have a lot of, like investigation. You got to investigate your case, right? And
Mhm.
there's a whole lot of language that already exists on what does that mean and what does it look like. And
Right.
you can, if I can get together a draft, it may just be, all right, bing, 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 we're good. So,
Yeah.
Okay, cool. Alrighty, thank you. I appreciate your help.
Absolutely.
and-
Do we have a next date yet, or are you going to send
Think
out
so.
something?
No, I'm pretty sure we have the, actually, let me stop sharing because y'all shouldn't see my full calendar on everything. Okay. I'm pretty sure we have another scheduled for, do we
Didn't
seriously
think we
not have?
did.
I think we
Oh.
just scheduled this one.
I think we
I thought we had
paused
another
the-
round of things, but I keep forgetting that the Civ Commit ones were at the early end of the monthly cycle, not the late end. Yeah,
I
we
think
will
we pulled all the future dates and then we're rescheduling them to figure out what we were doing
No,
internally. Is that it?
we didn't pull all
alright.
the future dates. It's just we only scheduled out until the last quasi criminal at the beginning of August, because we were operating under a
Oh crud, it's almost the
An
beginning of
August.
August.
yeah.
And what date and time is that quasi criminal?
It's August 6th at 1.
Okay, I didn't have that in my calendar, so I will add
I
that.
forget to send this one out to people too. No, that one has been. Okay. Were
Okay.
you on there?
I'll look for that invite.
Okay. Also, I'm not super convinced that we need the full work group meetings anymore. I may go ahead and cancel those largely because I don't think there's a lot of alignment between each of the 4 individual breakouts. They're
They're
just,
very different.
and we don't really
Mhm.
need the coordinated scheduling we can do over email and stuff. I'm not sure that it's a good use of our time to block out an hour for a meeting that it doesn't, I think it no
Accomplish
longer
much.
really serves it doesn't accomplish much. So, okay. All right, cool. I will reach out for further scheduling, doodle poll type thing. what I'm understanding, and Jordan, correct me if I'm wrong on this, we're anticipating doing a rollout of one set of standards per month, generally speaking. And I think quasi-criminal is towards the end of that rollout. And I'm not positive that we're actually anticipating having all quasi-criminal stuff sent out at the same time.
Yeah, I don't know that we've gotten that far. We're looking at starting with the criminal standards presented in August. And then
I-
probably for a vote in October is the way it's gonna line up. So I assume the juvenile standards will follow that, and then
Well, I figured delinquency was probably following criminal, and then dependency would follow delinquency, and then we'd start working our way through the quasi-criminal ones, is my guess.
Mhm.
Okay. All right.
I've got the quasi-criminal in my calendar. I'll look out for an email from you about a next civil commitment date.
Cool. All right. Thanks, Bailey.
Thanks, guys. Bye.
All right. See you later.
Yeah.